Hello, I'm Vince White. I'm an employment attorney. I'm not in my office. I'm snowed in New Hampshire, but I still got to get you these answers, right? Because you're not snowed in, or maybe you are, but you still need answers, right? So here we are. We're answering publicly posted questions from abo.com, getting people the answers they need from an employment attorney. And here is our question. Harassed at work. I'm being harassed at work and my boss is making false claims about my performance. What is wrong is regional are believing his false claims. So regional management seem to be buying into what he's saying. I started to forward my store's performance results to my personal email to prove that I'm being harassed because of the color of my skin. My question, can I be fired for sending the performance information to my personal email? The reason I'm doing that is so they can't delete the email if I get fired. Okay, so lots going on here. If your company, if your employer has a policy against emailing out information, and many employers do, and then you go ahead and do it anyways, well, one, there's a really good chance they're going to catch you because most companies who have that rule also have procedures for enforcing that rule. And two, yes, they can absolutely, if that's a rule and you break it, generally speaking, they're going to be able to terminate you for it, which is going to be, not great. That being said, and I would never encourage anyone to break their employment rules, but I know that often where it's not against the rules for an employee to get emails out, often employees will print the emails and take them home because often that is not as controlled, not controlled quite as closely as emailing information out digitally. I'm not encouraging you to do that, just saying I've heard of people doing that. Now, in terms of your concern about them deleting the emails, that's not as big a concern as you think. And here's why. If you bring a case against them, it sounds like for racial discrimination, right? Often, whatever attorney or law firm you hire would hire forensic IT at some point, right? So there's going to be discovery at some point. They're going to say we need all the emails. You're going to, there's production, there's document discovery that includes electronic documents as well as hard copies, and you're going to get that. And as the attorneys are going through it, you're going to go through it a little bit too, and you're going to say, hey, there's emails missing here. My store's performance reports are missing. Oh, interesting. Why aren't they giving us everything? So you make a motion to compel discovery. Maybe they say, oh, it doesn't exist. We don't have that. Really? That's very interesting. Why don't we go ahead and talk to the judge about an expert witness? We need to get some forensic IT consultants in here to see when you deleted those documents because deleted documents leave a trail, generally speaking, for forensic IT professionals. So if they're destroying evidence that can be useful in your case, that's really going to be construed against them. That is a big mistake on their part. It's a huge risk for them to take. It's not as easy as it sounds for them. It's really risky. It really is. If you have good counsel, who's going to spend a little money on your case, cares about the case, really wants it to maximize value and minimize risk while we're at it, right? So I would say be very careful with what you're doing, and also understand that it's not as big a concern as it might initially seem. I hope this helps. If it does help, consider liking and subscribing. It helps me to help more people just like you. And also, if you have more questions, I'm here and I'm happy to answer them. No strings attached. Happy to make more videos, whatever you need. Good luck.